Welcome to everyone, and thank you for all attending today. My name is Fred Phelps. I'm the Executive Director of the Canadian Association of Social Workers, and I am pleased to be moderating today's webinar. Before I go on introducing our speaker, I want to note all of the logistics, like how to access the recording of this presentation, how to download the slide deck, how to get your certificate of attendance, and all other information is down in the welcome widget that popped up when you logged on. If you didn't see it, it's all right. Click on the loudspeaker icon on the bottom of your window or type your question into the question box on the screen. Now, today's presentation will be approximately 30 to 40 minutes, followed by a question and answer period that I will moderate. And so please, at any time during the presentation, questions hit you, type those questions in, and I'll be asking them at the end of the formal presentation. Now, it is my pleasure to introduce our speaker. Mark Marzulay Nawegowo is proudly Ojibwe and a member of the Whitefish First Nations of Manitoulin Island. He has over 25 years experience working in social services, including over 17 years as a case manager with youth and adult offenders in the open and secure facilities, and over 9 years with adolescents legislated to a secure intensive treatment facility with mental illness. Mark is the founder of Indigenous and Associates and liaisons with organizations on courts of judicial matters pertaining to writing Gladue reports. Having held several positions within Indigenous organizations, Mark offers a wide range of Indigenous justice services, including research on community needs within the justice system, development and monitoring of restorative justice programs, peacemaking and sentencing circles, as well as Gladue writing and Gladue report writing services. In recent years, Mark has partnered with the Vancouver Community College to design the first intensive training curriculum for Gladue writing in Canada. Most recently, Mark has been asked to sit on the Government of Ontario's Expert Advisory Committee on Healthcare Transformation in Corrections. CSW is very honored that Mark has chosen to provide his experience and his expertise with us today. So without further delay, I will pass over the presentation to Mark. Mark, go ahead and take it away.
I'd like to say ani and hello to everybody that is in attendance. First of all, I want to say also is that because this is national, I would like to give thanks and acknowledge all the Indigenous territories across our nation. I'd like to thank the Canadian Association of Social Workers for inviting me to share my thoughts and my knowledge and what I feel to be one of the most important and informative reports ever introduced into the justice system to address the overrepresentation of Indigenous people that are incarcerated. When you look at the statistics across Canada, we make up 23% of inmates incarcerated within Canada, but yet when you look at our Canadian population, we make up only 4%. The overrepresentation of Indigenous offenders, I personally believe, is much greater than 23%. So what I'm about to share with you is through an Indigenous lens. It's a sacred story. It's my approaches to dealing with Gladue. And to first understand what Gladue is, you have to really understand the history behind it, to know where it came from through the legislation. So when you look back about 1994 in Parliament when it was first introduced, in the 718(2)E within the Criminal Code of Canada was enacted in 1996. And it was the beginning of a comprehensive review of the sentencing policy in Canada. So when you ask yourself what that entailed, the 718(2)E directed judges to consider all available sanctions other than imprisonment that are reasonable in the circumstances for all offenders, with particular attention to the circumstances of Aboriginal offenders. So when you go forward with 718(2)E, it was put to the test, and it was applied to a case that was before the courts, and this case was called R versus Gladue. The whole story took place in about the mid-90s. Jamie Tanis Gladue, a First Nations woman, was substantially charged with second-degree murder, but ultimately was convicted of manslaughter. That was handed down around 1999, April 23rd. While in her case, the sentencing judge considered some aggravating factors, it was presented that 718(2)E really didn't apply to off-reserve Aboriginals. So going forward, it was brought to the BC Court of Appeal. It was appealed on the grounds that the courts erred, taking a narrow approach to the 718(2)E. The purpose of the provisions was to address the historical overrepresentation of Aboriginals in the justice system, regardless of the place of residence or their lifestyle. But as you know, the appeal was dismissed. If you look back earlier, she was actually sentenced to 3 years and 6 months parole. In 2012, another case came before the Supreme Court, and as you see there, it's R versus Ipley, which reaffirmed and expanded on the principles laid out in Jamie Gladue's ruling. And actually it was two individuals. It was Metis Ipley and Frank Gladue. And it was the Frank Gladue case that actually made some astonishing changes. Both of them had breached long-term supervision orders. Basically, their case focused on the determination of a just sentence for their crimes. So the judge had a statutory duty imposed in Section 718(2)E to consider the unique circumstances of Aboriginal offenders. When you look at Ipley, they both were looking at 3 years. From here, the court held that the judges must pay particular attention to the circumstances of Aboriginal offenders in order to find out really like a fit sentence. And then the judges must take notice they had to look at the Gladue factors, so that's residential school, colonialism, displacement, and how this contributed to poverty, unemployment, substance abuse. And when we look at all these Gladue factors, these were in addition to the judges are requested to look at sentencing alternatives that were culturally appropriate. In the Gladue case, because of these Gladue factors that they found in his case, his sentence was reduced to 1 year because of addiction issues. Ipley received 3 years. So what happens from there? This is what happened going forward, and the development and implementation of Gladue reports came to be. So all persons who self-identify as Indigenous, that's First Nations, Metis, Inuit, and non-status, have Gladue rights. They have the right to have a report written for them for the consideration during their sentencing. So when you look at the Gladue report, I've broken it down to two views. One is the Westernized lens and the Indigenous lens. The Westernized lens has always been based on a platform of colonialism. And the wording within the Criminal Code of Canada, I feel, has always been through a Westernized view. So the sentencing judge must pay particular attention to the circumstances of Aboriginal offenders and consider all available sanctions other than imprisonment that are reasonable in the circumstances. But if you look at through an Indigenous lens, which is my approaches to what I call the sacred story. So since I've been doing reports, and I've done over 200, I've started introducing new ways to look at the report through an Indigenous lens because of historical factors such as colonialism, marginalization, the legacies of residential schools, and the negative impacts that they've had, are intergenerational systemic traumas that our communities have experienced, really pushed me to the realization that the actual word in Gladue report is a coined phrase. And it was just, I saw it more than just a document for the courts. I realized that it was a person's sacred story. It was an Indigenous person's, like, their life continuum, which unpacked, gave a series of events, and I kind of look at the old spaghetti westerns with Clint Eastwood, the good, the bad, and the ugly, that could explain why this individual became involved in the justice system and like where they are today. So when you look at it through an Indigenous lens, that meant the report was not just about writing. It was about traditional storytelling that captured that individual's life experiences and explained to the courts the Gladue factors that the Western justice system wanted to see. But there's more to the report than just being informative. What I took even further was that the report does more than provide that informative piece, that it actually moves towards being a mirroring, a self-reflection for the individual when you're writing the report. And before I go further into the slides, you'll see a transformation that I'm doing, that because of the coined phrase Gladue report, I've been introducing new wording, just for self-determination, self-empowering for our communities, is that I see it more as a sacred story report. So as we go forward, you'll see the wording change from Gladue report to sacred story and sacred story factors, just so I don't confuse anybody. You know, sometimes the people I deal with, the people that are incarcerated, never have a chance to be heard in life or share their story. Sometimes they never get a chance to see or hear what other people think of them or thought of them, whether it's positive or negative. Sometimes they never even get a chance to see what aspires them, what their goals are. And this is what the report provides them. For some, the sacred story is their only lifeline and a means to reflect and find what I call their healing journey. With my reports, through storytelling, I explain an individual's sacred story with a set goal to help an individual embark on a healing journey, whatever that may be, whether they're incarcerated or whether they return back to the community. So, how does the sacred story fit into a report? So over time, I developed what I refer to as the sacred story approach. So the basis for this, okay, Anishinaabe people in our traditions and our cultures, we've always reflected on many things in a circular way. The sacred story approach is no different, and this is what I do. It's all my approaches within the sacred story approach are all interconnected, and they can flow in either direction, completing the sacred stories. So as you can see, and I'm going to touch base on this in a few slides later, so I'll just outline this for now. So if you see in red, because it's the 4 colors of man, the gray actually should be white. But in red, I use a trauma-informed practice. In black, it's the sacred story process. In white, the concept principles of the approach. And in yellow, the sacred story factors, instead of saying the Gladue factors, which all in turn help you to create what I show here, the sacred story report for sentencing hearing. And like I said earlier, I'll break this down in a few slides. So let's look at how this is applied within the court system. So here, as you see, the report, and within that report, you have an individual's sacred story, and that captures, that explains the factors that give insight on how that person became involved in the justice system. It'll point out intergenerational systemic traumas. It'll look at good qualities and achievements and future goals. And lastly, at the bottom here, it's what I call the healing plan, and those are suggested recommendations to the judge. So those are really, again, really specific resources that are available to the individual so they can enter into a healing journey. So from there, the report is given to the judge, so the question mark, so he has a decision to make. So now he has the report in front of him, which basically gives gives the courts to really look at 3 different scenarios that can play out. And if you look at the top here, depending on what the situation is with the individual in court in their sentencing and their charges, there's 3 ways they can go. There's one which is community-based, provincial sentence, which is 2 years less a day, and you have your federal sentence, which is 2 years or more. So when you look at your community-based sentence, and each one of them, I should say, is a healing journey. So no matter whether or not they're going back into the community or incarcerated for the remainder of their life on DO cases or long-term offenders or NCR cases, it's all a healing journey, and this is the part that the courts really need to realize. And when you're looking at it, going back to community-based sentences, you're dealing with really unique resources that you have to craft into your report. So you have the NADAP programs, which is the addiction programs across Canada. You're looking at housing, because some individuals you're dealing with are homeless, and so you have to be able to present this into your report. Specific counseling, depending on what the counseling is. Then you're looking at ceremonies, connection with elders, and then community-based programming. But you also have to realize, too, that it's urban and rural programming. So in all these cases here, depending on where the individual wants to live or remain, you have to be creative and see what's available for them, whether it's in their community or within an urban setting. So when you look at a provincial sentence, 2 years less a day, you're looking at probation. You're looking at Section 84, which is transfers or supervision into the Indigenous community, and they could be specific to halfway homes as well. And as we know, provincial detention centers, a lot of it is dead time, and there's very, very, very little programming. And with the Sacred Story reports, 9 times out of 10, you'll find a lot of people that are being sentenced will want to bypass provincial sentence, and they'll actually request to you as a Gladue writer to have information put in their healing plan to the courts that they wish to move into the federal sentence, because there is a lot more programming available to an Indigenous person in the federal system. So when we go down here to the federal sentence, 2 years or more, this would include, you're going to be talking about parole. So if it's a federal sentence, your healing plan is going to be very well detailed and a lot more intricate, a lot more information, because you're going from the time that they're being incarcerated to right through to parole. Then you're looking at Section 81 and Section 84, which are healing lodges. There's dangerous offender cases, long-term offender cases, and not criminally responsible. And also, I forgot to add in here, there's the Mental Health Review Board as well. So I'm going to get into more specifics about the approach that I use, or the approaches that I use within the Sacred Story approach. So I'll first start off by the trauma-informed practice. So that's incorporating traditional knowledge and healing practices and applying these approaches to the complex trauma experiences that a First Nations, Inuit, or Metis person has experienced resulted from the impacts of colonization or some of the intergenerational traumas that have taken place in their life across generations. And with trauma-informed practice, it's really important to know as a worker, to really understand the impacts that have caused the traumas, look historically, and to understand the traditional healing practices that are available in the approaches that can really help that person move forward on their healing journey. So this actually should be Sacred Story Factors, so I apologize. So the Sacred Story Factors are historical and current life circumstances that tell the sacred story of a person to assist the courts in making an informed decision about that individual, and that's detailed in the Sacred Story report. So when you break down the Sacred Story Factors, now this is just a few, there's many, many more, but this is just to summarize a few. You're looking at family circumstances, their living arrangements. In some cases, the living arrangements have always been a jail. Associates, who do they hang out with? Friendships, what's their education? Lack of employment, did they ever work? What what are their career goals? Perhaps maybe it's tied into employment. Maybe they have an employee that's waiting to take them back. So these are important areas that need to be noted in a report. What's their financial situation? Their health. This is a big one. A lot of the times, a lot of individuals are tied into dealing with FASD, fetal alcohol syndrome. There's been many concerns about mental health, physical, emotional, spiritual. A lot of the times that are people that are incarcerated, their mental state is broken down because they don't see any hope or light at the end of the tunnel. Their biographical status, ethnohistory, which is all on anthropology, family history, past and present, their Indigenous history. What are some of the community factors that play a role? What is their connection to the community? Sometimes you'll do a report where there is no connection, and the only connection that they've actually connected with is while they've been incarcerated. What's the abuse? This one you have to approach with kid gloves, past and present, because this is tied into residential school, some systemic and traumatic issues, traumas that are pretty prevalent in a lot of the reports that I do write. This one's a big one. What is their attitude towards offenses, towards the offenses in their criminal history? And you're really not wanting to be factual about their present offenses, but you really want to find out if they're remorseful. And that's really important for the courts to hear. And for that individual to connect with themselves. And again, when I mentioned earlier about mirroring and self-reflection, what's their attitude? Are they really remorseful? Are they really wanting to heal? So when you look at the sacred story process, I've broken it down. Again, there's subcategories in this, but for the PowerPoint, I've broken it down into 8 categories. So first thing that happens is a sacred story is requested, and that can be done through the individual. That could be done through a court order. That could be done through the lawyer. It could be done through a Crown attorney. Most recently, well, not most recently, but in the last year or so, I actually had the opportunity to be one of the first companies or Gladue writers in Ontario to have the Ministry of the Attorney General actually bypass Legal Aid Ontario and have the reports ordered from the Crown's office in Kingston, Ontario, which I feel in my own mind that Gladue is a federal matter, and all of it should be put through court services. Then what you have to do is you have to arrange to meet the client. So you have to do an introduction. This is very important because in our communities, it's very important to build a trust. You have to be able to sit and tell the person, sit down and meet with them, introduce yourself, let them know what you're about, let them know who you are, what you're about to do, and prepare them for the Gladue report. So typically what I do in these situations is I'll go and meet with them. If they're incarcerated, I'll head to the jail and I'll meet with them for an hour or so, and I'll give them an explanation and handouts and prepare them for what's about to take place with the report. So I'll rebook another appointment to come and see them for roughly 2 hours. If they're in the community, I'll go and visit them. Chances are they're on bail, and then that's an opportunity to go to their community or their home and talk to them there. So getting back into the next process of the interview, when you meet them for their second time, you're getting into what I call the primary interview. So that's the interview of the individual that's having the report written for them. Then you're going to arrange, and then I'll go back. So from the primary interview, you'll empower them to tell you who they want you to interview to back up their primary story for the Gladue report or for the Sacred Story report. So you'll arrange interviews with the secondaries, and sometimes in these cases, they might not live in the same area as the primary, and they might live in different provinces or different towns where you can't get to them. So a lot of the time, your secondary interviews are done by phone. So from there, once you've received all your information, you're going to start your research and start gathering your information. And then you're also going to start researching your recommendations. So that's part of the healing journey. the suggested recommendations that you're going to give to the judge, depending on what that particular person's needs are and what their particular sentence is going to be. Because you really don't know whether or not they're going to receive a community-based sentence, a provincial sentence, or a federal sentence. And in some cases, you might have to write recommendations and do your research for all three sections. So community-based, provincial, and federal, and submit all three of them. So then from there, you begin drafting your report and you review it and check it over to make sure for grammatical errors and spelling and so forth. And then you provide, once that's done, you provide copies to the lawyer and to the courts. So the sacred story and principles and concepts are basically providing a well-balanced and objective report. You want to remain unbiased. You want to remain objective. You do not want to put your opinions in. This is very important. This is one of the reasons why across Canada there is so much scrutiny in the reports being written now because of a lot of biased comments in the reports. And I mean, these are going before the judges, and they really know about, you know, how to read into these reports, and they're really looking for the Gladue factors, and they're really trying to see how they're tied into that individual's life and how they became involved in the justice system, and frankly to explain why they committed the offenses that they did. So it also ensures the courts take judicial notice of systemic traumas and sacred story factors unique to that particular Indigenous person's sacred story, and that the courts adhere to Section 718(2)(e) of the Criminal Code of Canada. So where can a report be applied? With the sacred story reports, we're still pioneering these reports, and they're still breaking new ground. And each case that goes before the courts and a Gladue report is introduced, and it really changes the whole landscape of Gladue. So when a report is being court-ordered or issued, it's any time that a person is facing a loss of liberty. So that means going to jail. So a Gladue can be, a sacred story can be presented at a bail hearing, which is truncated, which is a shorter version of a report. So it's almost like a 1-2 pager that would give a summary of the individual, not extensive, and really enhance a healing journey that they can embark on right now if they were to be placed on bail, with the intention of later going to sentencing and then expanding on the truncated report to a full version Gladue report. So you're putting in more time and effort to expand on that report for the judge. Most of the reports are for sentencing. The other area that it can be used in is NCR cases, which is not criminally responsible. So you're getting into mental health cases. It can be presented at mental health review boards. It can be presented for dangerous offenders, so DO cases. It can be presented for long-term offender cases, just like the, as I mentioned earlier, Ipoli and Gladue case, long-term offenders. And parole hearings, which is not been used a lot, but it seems to be becoming more of a resource for individuals that are spending quite a few years in jail, 25 years. Matter of fact, I'm doing, I think, 10 cases right now in Quebec where individuals have contacted me that are up for parole after 25 years and wanting their, they've never had a Gladue done, and some of them only realize that they're entitled to one now after 25 years, and some realize that they should have had one and they want one for their parole hearing. Child apprehension cases. This is a big question mark. It hasn't really been introduced yet. I'm trying to break new ground with this, where a form of Gladue is represented in the court of law with apprehension cases. I think it's really important that these reports are introduced before there's any apprehension cases, so that kind of like, I guess I call it a circle of care, where all people involved in these cases have an opportunity in case management to be able to read, a report like this, so that it can give some insight into historical past with the family, as well as crafted healing plans, so the individuals, families, and the children can have a healing journey that's positive and safe. Intergenerational trauma is a big one. It's very much intertwined with systemic trauma. Intergenerational trauma or transgenerational trauma is when past traumas or experiences that have been left untreated are passed on from like one generation to another. It's what I refer to is what I call the unbroken circle. It just remains continuous. And really, with intergenerational trauma, it's really, in the case of sacred story reports, it's affecting that one individual that you're dealing with. And when you look at these traumas, they can be linked to residential school, the 60 scoop, and impacts of these events that occurred during this time still can be felt from years past and years to come. The unbroken circle is made up of your great-grandparents, your grandparents, parents, children to the siblings and to their children, and in some cases it goes back 5 generations. So when you look at systemic trauma, again, like I mentioned earlier, I see it as being intertwined with intergenerational traumas, and it affects all Indigenous people instead of just that one person you're dealing with. And kind of like an example I was looking at was when you see First Nations people and the perceptions of them being drunk and homeless on the street, and that this is true to all First Nations people, to be alcoholics and homeless across all nations. Another one is when you see an Inuit man sexually assault a family member, which is very common, and you perceive that to be true with all Inuit men, and that they make assaults like this across Nunavut. Again, this is associated with systemic racism and misleading perceptions. When you look at Gladue today, and you ask why they're still spinning the wheels in the judicial system, the Westernized justice system, there's layers upon layers as to why the wheels keep spinning. And when I thought about this, it brought me back to really knowing that from the judges to the crowns to the lawyers to case management, there's a lack of knowledge and really a lack of education about the reports. And you're talking like 14 years later, and it's still problematic, and it's continuously, I feel, getting worse because the overrepresentation of our Indigenous people incarcerated is horrendous. And I believe that the stats that are out there are not up to par. And I say this from a grassroots and frontline level because in talking with people that are incarcerated, Saskatchewan, Manitoba, the rates are, I'm sure, well over 100% when they're double bunking. The biggest one, there is no national standard for a proper intensive training program developed to this very day. There is not one certified Gladue writer in Canada. There is no program out there that will certify you under a national standard at all. I'm in the process of attempting to, well, not attempting, we're in a pilot project stage right now with Vancouver Community College to introduce the first intensive training program in Canada. And we are working towards, this is our intent, to work towards an actual certificate for Gladue writers. And I'm in the process of development of a national standard, National Alliance of Gladue Writers for Canada, to oversee the certification. So it's groundbreaking work, and it's a lot of work, but I'm excited to do it. And if you really followed or you know about the paralegals and their quest to be recognized as professionals, we're pretty much following on the same coattails, because when you have a Gladue report or a Sacred Story report court-ordered, and that you request a writer to write a court-ordered report, but yet they're not seen as a professional. Personally, myself, I have a problem with that, and there should be national standards set around that. Many reports continue to be scrutinized and not written properly. Again, this is tied into lack of training, lack of knowledge, lack of education, and really understanding the purpose and the importance of what's detailed in these reports. Some of these reports can be, again, from a truncated report, like a bail report, could be 1 to 2 pages, depending on a person's life continuum, their lifeline. Some of these reports go up to, I've written reports up to 35 pages long. Many court cases continue to take place, breaking new ground, and I mentioned this earlier, that as we go forward, Gladue is still being pioneered. So when you have cases coming up where there are parole cases or appeal cases, setting new precedents. So you just never know in front of you where the Gladue is about to go. So it's important to keep track of that and see where these cases are going. I personally believe that these reports need to be applied throughout all the court process, and it varies from province to province. Whereas Ontario could be different from Saskatchewan or Manitoba, or you go into New Brunswick where these reports they don't even have writers. They won't even consider looking at Gladue reports. And it definitely, and this is where I'm trying to make changes, is that it definitely needs to be seen through an Indigenous lens, not through a Westernized justice system. When you go back decades and decades before colonialism and colonization, our communities actually looked after our own people and our own justice ways, our own justice systems, and we were separate from the Westernized justice system, and there was a lot of forced assimilation. So we really want to be empowered and take back our ways of how we deal with our people. And like I said earlier, I mean, the justice system now is a platform, and I'll keep saying this is a platform of colonialism, and it needs to be recognized. And when dealing with our communities, the First Nations, Metis, and Inuit people. So what can you do in your role as a worker, as a writer, as a case manager? You really have to make sure that you really understand about this Sacred Story report, about, or referred to before as the Gladue report. You really have to educate yourself, reach out to the people that know, that can help you. You have to make sure that your client knows what their rights are. A lot of the times, individuals that are having their reports written for them have no idea what a report is or what their rights are. Like I said earlier, I've met a lot of people incarcerated, most recently in Quebec, where people, they spent 25 years incarcerated, and they had no idea that they had Gladue rights. And advocate where necessary. Make sure that these reports are pushed through to all levels of case management, whether it's through Correctional Services Canada, whether it's community-based, whether or not they're going to a healing lodge, whether or not it's a child apprehension matter. It's very, very, very important that these reports are used effectively and efficiently. They're very powerful in case management, I feel. They work collaboratively with, pre-sentence reports. They work collaboratively with any medical reports, and really, the report itself. I think that it's a benefit, not just to informing case management, but it also helps to inform the individual as well as they go on their healing journey. So that's pretty much it. But if you look here, there's some videos. There's some videos here that have been done on Gladue most recently, and there's a few articles here. And if you do look up my name on the internet, you'll see a series of articles and videos that have been done on my views of the sacred story approach. And I want to thank you for allowing me to talk about Gladue and or what I call now the sacred story. And I look forward to any questions that you may have.
Hello.
Hello.
Hello, Mark?
Yes, I'm here.
Oh, sorry about that. I guess I had an error on my technical issue on my part. Did you hear any of my thank you there?
No, I missed it, but I'm answering.
Sorry about that, and I'm sorry. I apologize to everyone on there for dead air. I apologize hugely. It appears that I had placed myself on mute, and that was a technical error on my part. Thank you very much, Mark, for your presentation. It was amazing. We have a number of questions from people all across Canada right now. I myself, through had a number of questions, and can't thank you enough for taking your time from Indigenous and Associates to provide your perspectives to things today. To kick things right off, just because there was a little dead air there, across Canada, you'd said, and this was a question that came to me while you were asking, while you were presenting, is that you said Manitoba isn't uplifting Gladue at all, and I'm wondering, from my understanding, and for the audience, maybe understanding is different. The court's based on precedent, so why, I guess, in jurisdictions like Manitoba or others that aren't using Gladue, why is that? And I guess as social workers, inherent to us are as advocacy. So how do we advocate for Gladue to be uptook in our province or territory?
One of the things with Manitoba, and I've dealt with them, and it's on my to-do list, is that they are top heavy with probation, and probation actually focusing on pre-sentence reports and what has been referred to as Gladue Content or Gladue Component. So it's a piece that's added on to the PSR, and typically these Gladue Contents or Gladue Components are done by non-Aboriginal people that are the probation officers. Now, the kicker on this one is that all this has to be done within an 8-hour window. So typically a probation officer only receives 8 hours to complete their pre-sentence report. And now they have to tack on, if they're requested or told to add on a Gladue Content, they have to add that within that 8 hours. And frankly, it's been brought up in the past where it is a charter of rights, or it's a violation of a person's rights to be able to have their Gladue report written in full, because there's just, in my opinion, and I've seen this just from experience, that you cannot possibly cover that person. So let's say you have a person that's 50 years old. You can't possibly, within 8 hours, cover a person's whole life continuum in a Gladue content that's part of an 8-hour process for a PSR, to cover their whole life and cover all the Gladue factors in that particular person's life. It's just next to impossible. When it takes when a person like myself, it takes 3 to 4 weeks to actually gather all the information.
That's in line with what I have heard, in the sense of the experience of often people in the courts hearing at the Gladue, just hearing in sentencing or hearing along that the Gladue report does not apply in this case, and then moving on. When I guess as social workers, and one of the questions here from Kathy is can a social worker request a sacred story report on a client's behalf?
Of course you can. And this is where we're breaking new ground, because really when you look at, so many people have been used to, it's the courts requesting these reports, but that's not the case. When you look at the different areas where people can order reports, it can be the individual, it can be the Crown Attorney, it could be a case management team, it could be a mental health worker, it could be family members, it could be the judge. Now, what plays a factor is who's going to pay for the report, which has always been the million-dollar question. And I'm a firm believer, and I'll stick to my guns on this, that because it's a Supreme Court ruling, it's the federal government that is responsible for Gladue reports. And when you look even deeper, when you peel back the layers, who across Canada, who pays for medical reports, who pays for any reports that the courts have ordered within sentencing? It's all through court services. So why is the Gladue report not placed in that pool of reports? And I stand strong on this, that it's court services that should be paying for them. But when you look at what's happening now in the landscape of reports, is you have the private sector where people are just going, I do not want to waste my time going through legal aid and all the red tape. I just want to get a report done. My family or community members, counsel, chief and counsel will pay for my report. Let's get it done. Or you might have an individual that is through legal aid, has a legal aid lawyer, and they will. There's money been put aside to have the report done. In the case with myself, being probably one of the, well, I think I am the only Gladue writer in all of Ontario anyway. I don't know where across Canada, but I've had court services in Kingston actually look after the reports, which clears up a lot of red tape, and the reports get done pretty quickly. And I use what you call a multidisciplinary team approach, which is nothing new. I've just applied it to writing the reports. So actually, I'm the only one in Canada right now that I know of that is able to write the reports within a regular full Gladue report within 3 to 4 weeks. Dangerous offender cases, long-term offender cases, NCR cases takes me a little bit longer to do the research because of the files, but I can usually get them done within 5 to 8 weeks, which is unheard of. And that's
you had mentioned that, and it's amazing to me that there is no national standards when it comes to Gladue writing. So I guess there's a two-part question that we have here. Is one, how do we as a profession, or how we as social workers can help develop national standards? And then the second part question here is, is there standards that you're aware of that are set in different provinces, or are there provincial standards set?
Well, there is, but it's what I call the gatekeeper. So when you have, on a provincial level, when you have organizations like Legal Aid, they set their guidelines and boundaries of who goes on a roster to be a writer, or they have boundaries on what their expectations are on going forward on how to do a report. I don't necessarily agree with them. I would have to take the time to to review the process that they use to be able to have their reports out there. I don't agree with Ontario 90-day rule where you have to be facing 90 days of incarceration. Again, that's a violation of a person's rights. Anybody that's facing incarceration or loss of liberty even for 1 day is entitled to a Gladue report. It's informative, right, for the courts. But again, getting back to your question about it's the provincial government that are gatekeepers, and they are basically, if I use the word, dictating on how a report is processed, and that's what's happening. And then to be able to set a national standard, it's a process that I'm working on, and the development stage where I can actually, my goal is to have an individual from every province sitting on the board, and I've already created the basis of the national standard, but I haven't launched it yet, and I was just waiting to meet with a few individuals within the ministry to get that process happening. But I think as a worker on the front line, it's by voicing your opinions and being transparent like I do, being that voice for many people that need to be heard, telling them that, telling officials and ministry people and other directors and people in case management that, yeah, there needs to be a set national standard for these, because there is none.
There was a number of questions here, both from Kiera and from Francis. Well, both of them enjoyed your presentation, and I thought it was very educational and inspiring, and also that you mentioned in the presentation about child apprehension cases. So they're wondering, how would Gladue be used in a child apprehension case? And I'm going to add on to theirs and ask if you've seen it in action, if there's an area that you've seen that has been applied to child apprehension cases, and if there is, wonderful. Please explain. If there isn't, how can we as social workers in child welfare advocate for that to be applied?
Well, I think that obviously it's going to be breaking new ground. It's not an actual Gladue report, but there's a means to be able to incorporate the framework of Gladue into cases where it can be informative to the courts or the case management or the people that are involved in an apprehension case. The situations across Canada, I think, are very gray. I've heard of similar situations where people have said that they've presented a form of Gladue within child apprehension cases, but physically, I haven't seen anything. I think it's more oral submissions, to be honest with you. I think there needs to be something legislated where these reports are brought in under the Criminal Code of Canada, where they're actually, or the Family Services Act, where they're brought in, where these reports are mandatory. In many child apprehension cases, it's like pass go, and they're in the courts, and then decisions are made instantly without actually slowing the process down. And what I call a circle of care, where all people involved in the particular matters in a child apprehension case, including parents, foster parents, are involved, because essentially the goal of these cases is in the best interest of that child, that individual. So the importance of developing a form like this, I guess a document, a report that could give a lot of insight into the matter, the case before the courts, would be so beneficial. I believe in BC, every province that I've been in, or people I've spoken to, they've been asking for me to set precedent, and there's cases that have come up where they feel that we could put a report in to see what would happen. And it's just, I guess it's lining the ducks up and having the right social worker, the right judge, and the right Crown Attorney, defense counsel to be able to say, okay, let's let's go forward with this. Let's put in a report and see what happens. And it would have to start off being pro bono, obviously, to be able to show the courts that this is something that's so much needed.
So I'm going to switch gears on you, and there's a question here. So what is, it goes back, I think, to the beginning of your presentation. What, in putting it together, Gladue reports in your experiences, what is a typical healing plan that you would put into your Sacred Story reports, or if there is a typical healing plan?
Well, there is no real typical healing plan. The healing plan is based on the individual's specific needs. So going back even further, when I interview somebody, so when I spoke about the primary interview, when I spoke about the primary and secondary interviews, and I'm actually interviewing the person that's having the report done, and then I'm interviewing the secondaries, which are the people that are in this person's life. It could be mums, dads, aunties, uncles, sisters, brothers, other workers that have something to say about that individual's life. So from there, I'm actually pulling out pieces from the interviews that stand out to me of the areas that could be from intergenerational trauma, systemic traumas. It could be bereavement. Let's say a person, a family member passed away and they've never healed from it. Well, as a worker, you know very well that that's part of the concern with that individual, that they've never had an opportunity to heal. So you make note and know that in that healing plan for that healing journey, that possibly that's part of some of the resources that you have to look for, which is bereavement. Everybody's story is going to be different, and everybody's sentence is pretty much going to be different, from community-based to provincial to federal. And if it's in the community, you're struggling with what I call, so if you look at a circle within a circle, I always look at the inner circle, which is First Nations, Metis, Inuit resources. And a lot of the times we're strapped on what we can access or utilize. So sometimes you have to go outside that circle, and the outside circle is the non-Indigenous programming. So you have your John Howard societies, the E-Fries, and in some cases the individuals that you're dealing with want to go to those programs because they've had some amazing results. So they don't want to go to Indigenous programming. So there's a whole bunch of variations, and really it's based on the individual's needs. When you get into the provincial and federal programming, I'll be first to tell you that the provincial programs that are available, excuse the expression, but they suck. There's nothing in place. It's a lot of dead time. It needs to be improved. In the Ministry of Correctional Services Canada, the ministers they know of this, and they need to improve the programming. They put a lot of effort and money into changing the 728 under the Correctional Services Canada mandate for programming, but it needs to be pushed more into the provincial system, because when I write my reports and I'm doing the healing plan, I make it very clear the lack of programming, so that they're aware in each one of the reports that you want this person to be a productive member of society. And this is what the law says, is that they want people to be productive members of society. They want to reduce the recidivism rate. Well, then have the programming available, whether in the community or incarcerated, so that these people can work towards a healing plan, so they can have a better way of life.
Well, we're coming close to the end of our presentation now, Mark, and
okay.
I think I'll leave you with one last question. And
okay. You
spoke at the very onset about the overrepresentation of Indigenous people in incarceration. And spoke a bit today about how Gladue reports could help address the overrepresentation. And so I guess the two-part question is how do you see Gladue helping to address the overrepresentation? And the other one, in your experience and the work that you're doing, how would you see it, or what are the first kind of steps we can take to look at the justice system and evolving it, rather than to amplify the impacts of colonialism to decolonize the justice system? I know that's a large question, but I just want to hear your answer on
well,
that.
I'll start with the overrepresentation, and it's one of the things that happened. It kind of like set us back a little bit with the mandatory minimums, where this really pushed a lot of our communities to be more incarcerated because a lot of our communities are marginalized and we don't have the means to be able to access sureties to be able to get back into the community on bail. It's just might as well pass go and go straight to jail. So it was like there was a Maclean's quote that said the jails are becoming the new residential schools because we're overpopulating them, and to reduce the overrepresentation of boy, that's a big question, of Indigenous people in incarcerated. Well, I think one of the things we have to do, there's two sides of it. From if you look at the front end of the train and the caboose, so look at the front, there has to be education, there has to be knowledge. The platform of the justice system really needs to understand what Gladue is, or actually what the sacred story is. Many people can recite and read and understand legislation, which is 718-2E, Ipley cases, the R versus Gladue, and you can repeat it and repeat it and repeat it. It's not going to change. But to really understand through an Indigenous lens what the report is, what a sacred story is, the reflection on an individual's healing journey, and this is what I really promote and push. That's the true essence of a sacred story report. That's exactly what the courts need to know. They need to have an understanding. They need to use their time productively to be able to take the hours or the means to be able to talk to people that really know what these reports are about, and so that I can, for myself, be able to share the knowledge of what the impacts of these reports and can have on the individual.
CSW was opposed when mandatory minimums came into play, and will continue to oppose, and we'll hope that hold the Liberal government account to their promise to review mandatory minimums, because we're with you in the sense that it really takes any flexibility out of the justice system, especially applying Gladue. And so with that, we are out of time for today, and just for logistics for people, you can access your certificate of attendance now if you viewed over 60 minutes or more of this presentation. And if you don't have the time to get that or download it, the further reading right now, if you wait 24 hours and then log in again, the platform will have saved your progress, and you can watch parts of this webinar again and download any resources and get your certificate. To close, I can't thank Mark enough for taking time out of his busy schedule to present to us today. I appreciate it very much, and Miigwech, thank you very much. Everyone have a great week.
You're welcome.